హలో వాయిస్ వినపడతామా చూడు. హలో 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 అలా ఎంగనా హలో 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 వసంత వాయిస్ వస్తుంది. బ్యాటరీస్ మాస్ రాత్రి ಅವನ ಎಪ್ಪಿ ಎತ್ತನ ಹೋಗ್ತಾನೆ ಕಂಪ್ಲೇಂಟ್ ಇದ್ರು ಫೋನ್ ಮಾಡಿ
ఏమి రాబా ల్యాప్టాప్ తీసుకుని రాబా ఎంతసేపు బా నడిచి రాబా ఏం బా లిఫ్ట్ వాడుతా ఉన్నావు రా తొందరగా రా నీకోసం అందరు వెయిటింగ్ వీడియో కాల్ మాట్లాడుతాను నైట్ అయితే వీడియో కాల్ మాట్లాడుతూ పర్వాలేదు
நிறைய பேர் அடிச்சிருக்காங்க.
Next year the admission opening.
Very good morning, all of you. Hope you are doing well, and I hope you all are enjoying our special lecture series program. But it's very difficult. I think you all are enjoying our lecture series. Yeah, some of the students they told those who are sitting page, they are unable to understand. For them, I would like to tell one thing. Dear students, mind is a restless part. Mind is a restless part. You are here physically present, but mentally. You are here. Your mind is with your best friend. Your mind is in your hometown. Your mind is in the Reliance market. So please concentrate. When others are able to write, when others are able to understand what my esteemed colleagues are presenting, delivering a best lecture, what about others might not understand? So please concentrate. Try to concentrate and write something. Then only you will be able to understand the concept, the idea, what they are delivering or discussing here. So please concentrate. Don't create problem for others. Maintain high discipline and let us learn. With this, let us start today's business. With this, I would like to invite my esteemed colleague, Daniel, to start today's lecture. Daniel, please.
Thank you so much, warm welcome, and good morning to all. Can the school little down? So shall we begin? Yes. Active ஆருங்க. Shall we begin? So Nitish, நேத்து நம்ம என்ன படிச்சிட்டு இருந்தோம்? 2 days ஆச்சுண்டா. You were there in my class. Yes, what were we discussing yesterday? Huh? Yes. So then the rules of drafting and also we plain the just பார்த்துட்டு போனா ஒரு தடவை கூட டீடைலா டிஸ்கஸ் பண்ணலாம். We'll discuss again later today also. Okay. So what are the rules in basic rules in by drafting a plaint or a pleading? First you should have an outline of what you're gonna write. எழுந்து தொடங்குனதுக்கு அப்புறம் எடிட் பண்ணா ரொம்ப கஷ்டம். It will be difficult for you to edit. So you should first of all you should have an outline, listen to your client's grievances and come to a conclusion. இது என்ன should we file a attachment petition, attachment suit இருக்கணுமா இல்ல money suit மட்டும் போதுமா, or whether it should be an injunction suit alone, or what kind of relief, or should be a declaration of any suit, declaration suit இருக்கா இல்ல partition suit, whatever it is. And the idea, you should have that idea, then only you should start to draft, whether it is a plaint or a written state, whatever be it. So first of all you should have an outline and just see in which court it could be tried, jurisdiction irukka. Jurisdiction, while talking about jurisdiction, which all sections under CPC deals with jurisdiction? 15 to, so what does section 15 says about? What does section 15 says about? Number suit, whatever we file should be at the lowest court. Lowest court தான் file பண்ணணும். Okay. And what does section 16 says about? With regard to subject matter, if it is an immovable property, if it is a wrong done to an immovable property, if it is with regard to what is it? What do you say? We'll discuss section 15 to 16 in brief. Okay. If it is a partition suit, or if it is for a recovery of possession of movable property, and with regard to any wrong done to a movable property, whatever it is, and the subject matter enga situated arko, that place the court has jurisdiction to try such kind of suit. That is what dealt under section 16 of CPC. What does section 17 says about? We are uncertain, we are not sure in which jurisdiction we have to try the suit. Maybe the property lies in such a way that half of the jurisdiction with Tamil Nadu and half of the jurisdiction with Andhra Pradesh. So we are uncertain in which court we have to file the jurisdiction, to file the case. So in such a situation, what we can do? Either court you can file the suit. In the same case also, when you are uncertain, you are not sure with regard to which court you have to file, and with the permission of the court, in either court you can file the suit. And the court with jurisdiction try pandradhu. Clear? Is it clear? So these are the just, and section, what does section 20 says? It's important. Yes, louder please. Where the defendant resides, exactly, or carries his out business, wherever he carries out his business, and the place in jurisdiction court to try pandradhu. So in these are the factors you have to keep in mind before framing a plaint or before instituting a suit. Ini nama just on the outline paapom. What is an outline with regard to the plaint? Enalla irukkalam. Just a recap mathiri. First enna irukanum? Three things has to be there. First, the heading, in which court. Then the title and in the type of suit neenga file, what kind of suit you are going to file, and the content, the body, and the prayer, jurisdiction, all those things has to come in the content. So the formal part and the contents of a plaint is the head, title, and the body. The heading la ennalla varala, what all comes under the description of heading. First one is the court in which we file. Before the honorable dash, whichever court it is. Whichever court has jurisdiction, whichever court you are going to file the suit. Before the honorable court, or you can write in the court of dash. And place has to be mentioned. Like in the, before the honorable municipal court, like in whatever it is, in Andhra Pradesh, or Tirupati, whatever it is, before the honorable dash court, the place of the court, where it is situated. Then what comes? Then what comes? Suit number. What kind of suit it is? Whether it is OS, OP, OPMP, EP, OP electricity, whatever the different types, or if it is a, you have any doubt? If it is whatever and the type on the type, even if it is IP, insolvency, petition, whatever it is, you have to mention that type. That is called the title. Type comes under the heading of title. Then what comes? Name of the parties. Just you need to mention the plaintiff, its name. Defendant, its name. If there is one or if there is more than one plaintiff, in that portion you need not specify all the names. You can write Danya and one other or two other. Like in defendants also, Danya and two another. Like that way you need to mention only in the beginning part. Then what comes? Are you getting an idea or mental structure? Just imagine, okay. First, before the Honorable District blah blah court, then comes the OS number or what it is. Then comes the name of the plaintiff and the defendant alone. Then what is it? The cause title. Cause title. In under what title or under what you are filing the suit. Plaint filed under section 26 read with order 7 rule 1 of code of civil procedure. If it is anything specifically you are asking for, then the specific law can also be mentioned. Okay, then what you have to write? Now comes in detailed description of the plaintiff. Detailed description includes the name of the person, his age, his son of whom, his address, everything. This is the detailed description that has to be given of each and every plaintiff and each and every defendant in the suit. Okay, and it is very mentioned, you might have learned with regard to necessary parties, misjoinder of parties, and it is very important by whom all you include in the party array. Okay, so after that, plaintiff had described what is the sentence you have to write? All notices, processes to the plaintiff, to the above said parties has to be served in the above mentioned address or to his counsel. Because counsel is the one it is being sent, or to his counsel. Then the details about the defendants. Defendants or the details, each and every defendant has to be mentioned. Then also you have to write all the processes, notices to the above said defendants has to be sent to the above mentioned address or to his counsels if he may engage. Because plain file பண்ணும்போது engage ஆகல. He hasn't engaged any counsels for. So if he may engage. So that is a sentence we have to write. Then what is the thing? Now we are going to the body of the plaint. Body of the plaint. The title பார்த்துட்டோம் first. Next நம்ம பார்க்க போறது body of the plaint. In body of the plaint, what all you have to include? What is the first sentence? The plaintiff begs or plaintiff the above said plaintiff states as follows, or the plaintiff begs to submit as follows. So this is the first sentence. I'll underline panni, center level underline panni, and then you begin your plaint. Then after this you begin your plaint. The first paragraph. Generally what will you begin with the plaint? You have to give me some kind of relief. Is that how you have to begin a plaint? First, you have to mention how you and how the plaintiff and the defendant relationship. Is it if it is a partnership firm, the partnership create under what agreement? The partnership or the firm the forward head office each and every detail has to be mentioned. If it is with regard to any, even if it was a paditarkam, what paditarkam na like, or there's a dispute with regard to a pathway. How long, and the pathway use, how long were you using that pathway? How is it by easement by necessity or easement by grant? Whatever it is, it has to be specifically mentioned. And also the description of the pathway. If it is for a execution of a sale deed execute பண்றாங்க, if it is for execution of sale deed, and he made a breach, if he did not perform the said sale deed, then what all things we have to mention, and the schedule has to be mentioned in proper. Who was a prior owner of the property, and how did he gonna acquire the property? What was the consideration that they wanted to enter into? And then that is how you should begin the first paragraph. First two paragraph konja kada da. You should have that what style of writing a story. Just up till you should not write a whole huge essays like that thing. Just two paragraphs about how you become related with the other part. Clear so far? Then the third or fourth paragraphs begins with the breach armature. What was the default made by the other party? What is the actual grievances according to you? What was the cause of action? All those things. And what was the default, and all those things. And it is make sure you don't write any evidence. Material facts only need to be stated. Not any kind of evidence has to be stated. Clear so far? Then, and very important thing is what? Cause of action. When and where the cause of action arose. I'm repeating again and again for past 3 classes. Why? Because it is very important. Cause of action has to be stated clearly. Clear? Yes or no? And date of cause of action. And a cause of action may be series of events. Cause of action, for example, now ஒரு agreementல enter பண்றது, I am willing to enter an agreement with you stating that I want to sell my property for about 10 lakh rupees. Say January 1st I am proposing it. You have signed it and you said within 6 months you will give me the rest of the sale consideration, but you made a default in the payment. And in such a circumstances, have you learned about specific relief act? Specific relief act. Okay. In under specific relief act, this is a specific performance contract, right? There is a contract and I am willing to perform on my part. He has committed a breach in performance, and even after 6 months, even after the grace period, he is not willing to perform. He is not ready to give the whatever consideration for the sale. Then, as per specific performance, I should prove that, I should make sure there should be a specific pleading that I had the willingness, I had the capability of performing the same. Specific performance பண்றதுக்கு எனக்கு willingness இருக்கு. It is section 16 of specific performance act there is a provision says that persons who cannot perform specific performance. Why? Because if a person is unable to if a person is unable to prove the code that he doesn't have the willingness or if he doesn't have the capability to perform the same, he will be barred from performing it. So, in order and the bar மாத்துறதுக்கு வேண்டி we have to proof எல்லாம் evidence stageல தான். But in your pleading, it is mandatory that you should plead that you had the willingness, you had the capability of performing the same, but the other party failed to perform his part. It has to be clearly mentioned, right? Okay, so far is it clear? So pleading must be very specific. Please remain silent at the back. So far is it clear? First, I was talking about date of cause of action, right? 1st of January, I entered into agreement. So cause of action, that day itself, and maybe after 6 months. So each and every day has to be mentioned. On Jan 1st, the cause of action arose. And the cause of, important if the cause of action, I sign maybe in Kerala, say plot may be in Andhra Pradesh and the person residing it might be in Delhi. So there also you have to mention how to promote a different இருக்கும்போது where and where, so three causes of action is there. We are clubbing all the causes of action together, and all the three causes of action arose at three different places. So there it has to be filed. அதுவும் clear-ஆ mention பண்றதுக்கு தான் we have to specifically mention each and every places with date. புரிஞ்சுதா? And according to section 20 and according to section 15, whatever it is, நம்ம அந்த அதை அனுசரிச்சு we have to file the suit. Clear? Yes or no? So that is with regard to cause of action. After cause of action, so we have concluded. We have conclusion. We have what we state. We state that since the scheduled property lies within the jurisdiction of this jurisdiction of limits of this court, the court has the right to file this suit. Appreciably, the causes of action we will wind up. After cause of action, what is the thing we have to ask for? Huh? Valuation. Valuation also is very important for determining the pecuniary jurisdiction of the court. If it goes beyond 10 lakhs, it is the higher court. The subordinate jurisdiction would be with the subordinate court, and if it is below 10 lakh, it is with the lower court. So that also has to be clearly mentioned. And then what there are different, I don't know with regard to Andhra Pradesh rules. In Kerala, we have legal benefit fund and legal benefit one, then court fees இருக்கு. அதே மாதிரி ஸ்பெசிபிக் இப்போ இன்ஜங்ஷனுக்குன்னா இவ்வளோ சூட் இருக்கு, மணி வேல்யூனா இவ்வளோ கொஞ்சம் specific amount has to be paid. But at the time initially you have to pay only 1/10 of the total amount has to only to be paid. But before the evidence stage, that is the pre-trial steps, whatever the balance court fees, you will get new terminologies எல்லாம் நீங்க கோர்ட்ல போக படிப்பீங்க. BCF ம்பாங்க, ஒன்றும் புரியாது. PTS ம்பாங்க. DCF means balance court fees. Okay, whatever the court fees that remaining has to be paid, that has to be paid. Then if it is PTS means pre-trial steps before the trial begins. If any documents are not produced by original produce panna irukna, you have to produce those documents. Guys, please remain silent. Clear? So that is with regard to jurisdiction. That is with regard to the valuation. Next, Anna. Huh? Yes, exactly. Prayer. Prayer must be very, very specific. Meaning, whatever you pray for is the thing you will get the relief. You have contended throughout the competition, throughout the planes, you have contended so and so has to be given, he has made such kind of breach, but you are not asking for any kind of relief. What is the use in it? So what is relief must be very, very specific. If you want an injunction, if it is mandatory or a prohibitory, what that must be specifically mentioned. If it is any kind of alternative, you are asked for money suit, and also the interest. If money suit na interest 6% per annum interest adum kekano. And if the court fails to do, not fails, if the court finds it another solution irukuna, we can also opt for alternative reliefs as well. If the defendant is unable to provide the same, if the money is unable to give the debt, then you can ask for an alternate relief, like attaching his property, right? So under relief, okay. So in the schedule, even if it is movable, even if it is immovable property, now if it is movable property might perish or might get destroyed. So when you wanted relief with regard to movable property, it is mandatory that you have to state a liquidated sum equivalent to the movable property. Say for example, maybe a load of vegetables with regard to vegetables, maybe transportation he made a breach, because of that vegetables got perished or anything, and the vegetables we cannot ask for the vegetables, but instead of that we could ask for a money equivalent to that, or the loss that he has incurred equivalent to that. So if that liquidated sum has to be stated in the plaint with regard to movable property. And an immovable property, you should be very specific about the schedule also. Because even though code allows the attachment, code the director attach பண்ண முடியுமா முடியாது. He will appoint an army. Other procedure இருக்கு, attachment procedure இருக்கு. And then army as a person is appointed by the court. He will go to the court only with the schedule. We might not have any other thing. In the schedule, what all things has to be there in the schedule? All the limits, boundaries has to be mentioned correctly. Then first of all, the district, the place, the taluk or what sub the district, whatever it is, it has to be mentioned. The survey, if there is resurvey has to be there. If it is a then block number, block number, all those details. If there is building, all building with door number, that has to be mentioned. All specific details has to be there in a schedule. Clear. And if it is about 2 or more schedule, and all the schedule has to be numbered. Schedule A, Schedule B, Schedule C, and the petition plain schedule property A, plain schedule property B. அப்படிதான் mention பண்ணி schedule line வரணும். In schedule, you have to give a brief description. That property comprising under resurvey number or survey number so and so, with extends to 10 cents of property in this village, in this registered in this SRO, whatever it is. Hereinafter described as Schedule A property. Hereinafter described as Schedule B property. ஓரோ தடவை எடுத்து சொல்ல முடியாது நம்மளால, because it will get lengthy. So instead of that, in short, we will mention the schedule name. We'll give a name, and that name has to be throughout the plane. It has to be used. Clear? Clear? And at the end of after the evaluation, after the prayer, then you have to mention the schedule. After the schedule, what has to be done? Verification. Then after that, actually the counsel for the plaintiff signs, and also the plaintiffs also has to put the signature. Then before that, one more thing has to be there. List of documents. What all documents that you rely on, starting from the notice, advocate notice that you have sent to the other party, each and everything has to be produced with number, like exhibit A1. We made documents in exhibit solo, exhibit A1, A2, A3, like that way. Exhibit A1 produced on behalf of so and so, and also other date must be there. If you are relying on an advocate notice, copy of advocate notice dated so and so, sale deed executed on so and so date, or sale deed number executed on so and so date. Sale deed number இருக்கும்ல, blah 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 /2020 அப்படி. And even if it's whatever deed you rely on, whatever document that you rely on, has to be given with date in a separate heading called list of documents. இதுக்கு அப்புறம் தான் what comes is the verification. Verification is mandatory. Okay, all facts stated above are true to the best of my knowledge, belief and information. ஒரே ஒரு sentence தான். This is actually ayudham, like shield, Achilles shield for the advocates. Later on, the clients cannot deny that this is not what I have pleaded for, because they have verified. All facts stated above are true to the best of my knowledge, belief and information. So this statement has to be signed in the presence of the advocate. No, கொஞ்சம் யூசேஜ் எல்லாம் இருக்கும், like we feel that வயசானவங்க வீட்டுல கொண்டு போய் வக்காலத் சைன் பண்ணிட்டு கூட்டுருவேன். Like request you people, don't do such a thing. Don't allow. Ask your clients, even though they are not well, ask your clients to come to your chamber or anything. Sign in front of you, because நிறைய cases where later on they would deny. This is not my signature or anything. அப்படி பண்ண chances இருக்கு. So ask them to come to your court office. Ask them to sign in your presence. Clear? Then after verification, that is the exact of plain. Plain should be accompanied by affidavit. Exactly, it should be signed by accompanied by an affidavit. Affidavit, if there is more than one plaintiff, any one plaintiff, the one person who signs the verification, right? He can avaroda perla I, so and son of so and so, solemnly affirm and states as follows. The plaintiff, we will write dialogues, right? Instead of that, we have to draft in such a way that I. That is the difference between plaint and affidavit. அது கொஞ்சம் minor difference தான் வரும். That in plaint it is like the counsel representing the plaintiffs. So it will be in that form, indirect form speech. The plaintiffs and the defendants were siblings. அப்படின்னு நம்ம பண்ணுவோம். And when it comes to the affidavit, what comes? I, myself, and the defendant were siblings. அப்படி the format will change. Only minor changes would be there in the affidavit, and it has to be signed. And the sign பண்ணும்போது, even in affidavit, that has to be verified by the advocate. Affidavit is given by the plaintiff, one of the plaintiff. And on the affidavit period, advocate has to put a seal, other seal getting solemnly affirmed and signed this before me in my office at so and so on this date, 23rd date of January 2023, who is personally known to me and signed before me. The tender dialogue work. Understood. And that has also been given at the end of the affidavit. In the whole set, the plaint. The plaint and affidavit kuda சேர்ந்து வருவதான் plaint. And while you file a document, either a duplicate must be there. If there is no duplicate, it's a ground for rejection. It has to be filed in duplicate. And why? Because we and all the copies, இப்போ எவ்வளவு defendants இருந்தாலும் எல்லா defendantsக்கு ஒரு copy வச்சு file பண்ணணும். And if there is 20, 30, 40 defendants are there, all the 40 defendants we have to file a copy for them. Clear? And whatever documents that, for example, if you produce a document which is a copy, photostat copy won't be taken in the exhibits. Adu mark panna maatanga. Before the trial, that is why we are giving a proceeding like pre-trial steps. Before the trial begins, you will be given an opportunity to produce the attested copy, either attested copy or the original of the said deed. Clear so far? Doubt irukka? Yes. Photocopies will not. Haven't you learned Evidence Act? What is secondary evidence 64 and what all that says? Yes, photocopies won't be entertained at court. Attested copy certified copy has to be produced. Attested copy they won't entertain. Certified copy has to be produced. Certified copies we will learn in the section. Yes. So please refer to that. Practice once you start to practice, you will understand. So is the plaint clear? Is there any doubt or should I move on to written state? Do you have any doubts, further doubts with regard to plaint? Written statement, there is no much time, only 5 minutes left. Tomorrow, next class, I'll take written statement. You will get it. And you will have to write it. And yesterday, out of the box, I'm telling, yesterday, Moot Code competition, only I created a group, but some of you have given a WhatsApp numbers which are not there in WhatsApp. Because that was your garbage share. Your number was not there in WhatsApp. We are not only. Then you have to verify it. So on afternoon I would come and ask for only 10 members need to be added to the group. Then I will send you the model and also the rules for how the competition will be conducted and the decorum and everything, all the details with regard to how competition is to be held. All those details will be given by afternoon. Clear? Any more queries? Huh? Paint. There is no restriction with regard to how many pages you want to draft the planes or not. It could be any number, but அதுக்கு ஒரு formats இருக்கு, legal paper இல்ல. There is a legal paper you have to, but now A4 has also been accepted, but mostly we follow the legal paper method, and it should be printed on one side only. Two sides print பண்ணக்கூடாது, and the space, the அதுக்கெல்லாம் rules இருக்கு. The space விடணும், sideல space, கீழ space. There is no restriction with how many pages you want to write. Any more queries? Please remain silent. After this, I will be engaging the next class. After this statement, I will give you a hypothetical situation so that you can draft planes and written statement. Okay. Thank you for this.
Good morning. So till now we have discussed on Advocates Act 1961 with regarding to section whereby the advocates receive their right to practice. Then we have seen section 24, which are none other than disqualification for advocates. And case laws with regard to that also we have covered. And we have seen section 3 regarding to State Bar Council, functions of State Bar Council under section 6, election of State Bar Council, etc. Now, section 4 of Advocates Act deals with the Bar Council of India. Section 5 says, deals with again stating that it is a statutory body. What is a statutory body? Bar Council of India is a statutory body. There shall be, section 4, there shall be a bar council for the territory to which this act extends to be known as Bar Council of India, which shall constitute of the following members: ex officio chairman, that is Attorney General; ex officio vice chairman, Solicitor General. Like, Attorney General is a constitutional position. We know the article constitution itself provides for the provisions for Functioning of or appointment of the Attorney General by the, you might have studied constitutional law, by the, who is appointing the Attorney General of India? The President, under the advice of the Union Cabinet. Now, coming to the part of section 5, Bar Council to be body corporate, titled section 5, Bar Council to be body of corporate. Now, Bar Council of India, the organization, the body which has been formulated so under section 4 of the Advocates Act 25 of 1961, it's a body of corporate. It's a statutory body and it's a body of corporate. Meaning, what do you mean by company? If you have studied company law, you might know. Body of corporates. It is a legal entity. It's a legal entity. A legal entity having its own legal rights. Legal rights. It is a corporate body. It is having legal rights of its own. It is having legal responsibilities as well. When we say it is a corporate body, please note it down. When we say it is a corporate body, it is having perpetual succession. Perpetual succession. What do you mean by perpetual succession? Again, company law. Even despite of its members being insane, dies, suspended, it continues. The body continues. The body will continue. So it is body of corporate having perpetual succession. Whereby we can say that, again, company, like the company, it is having a common seal. Like a company, Bar Council of India, the body of Bar Council of India, which is a corporate body, which is a statutory body again, it is having a common seal, it is having perpetual succession, it is having legal rights as well as responsibilities, power to acquire, hold property in its name. It is having power to acquire property, hold property in the name of Bar Council itself. Again, it can hence enter into contract. Again, in its name, it can enter into contract with others. So, it can enter into contract, it can hold property in its name. Therefore, it can sue or be sued also in its own name before any court. Bar Council of India can be sued or it can sue others in its own name. Okay. These are what we can see in section 5. I read section 5. Bar Council to be body corporate. Every bar council shall be body corporate having perpetual succession and common seal, with the power to acquire and hold property, both movable as well as immovable, and to contract and may by the name by which it is known sue and be sued. These are what is given or envisaged under section 5 of the Advocates Act. Now section 6 we have already covered with which are none other than functions of State Bar Council. State Bar Council. Now what we need to cover herein is nothing other than the part of section 7 of the Advocates Act, which is none other than the functions of Bar Council of India. Let us deal with it. Now, section 7, functions of Bar Council of India, it has laid down certain functions which are cut short. I will be dealing with few. The functions of Bar Council of India shall be to lay down standards of personal conduct and etiquette to advocates. As I told you, right to practice is solely entrusted to an advocate who is enrolled himself in the state roll. And they are regulated as well under section 34. Right to practice, we have seen it is controlled by the rules laid down by the state bar councils, Bar Council of India, etc. High Court also lays certain rules as well. And not only that, functions of the Bar Council of India is also to regulate the functioning of the advocates with regarding to their etiquette, with regarding to their professional conduct also. First function. Second, lays down procedure to followed by the disciplinary committee. Now, section 36, a disciplinary committee has been formulated in order to take disciplinary actions against those lawyers who are doing professional misconduct. Now, what are the proceedings to be initiated by this disciplinary committee? Again, shall be dealt by or laid down by the Bar Council of India. Again, another function of Bar Council of India is none other than laying down procedures to be followed by the disciplinary committee and the disciplinary committee of state bar councils. Disciplinary committee of India, Bar Council of India, and the disciplinary committee of the state bar council. Again, so if there is a disciplinary action taken by the disciplinary committee of state bar council, appeal to be forwarded to the Bar Council of India disciplinary committee. We will come across those. Now, third one, if not all, safeguards the right, privilege, interest of advocates, like the same function of the 6, which we have seen in section 6 of Advocates Act. What is that? State Bar Council also protects the right, privilege and interest of advocates. Likewise, India, Bar Council of India also is vested with the function or a duty to safeguard the right, privilege and interest of advocates. Now, promote and support law reforms, law reformations to be brought up by the Bar Council of India in the society. Bring up changes with regard on law, bring up reformations on law is also a duty which is vested, also a functions which is performed to be performed by Bar Council of India. Please note it down. Promote and support law reforms. Next, to deal with and dispose of any matter which may be referred to it by the state bar council. Next point, whatever matters which has been referred to the Bar Council of India, by whom? By the concerned state bar councils all around India. Now these matters has to be disposed of by the Bar Council of India. Again repeating, the reports, any suggestions, any papers which has been so forwarded by the State Bar Council to the Bar Council of India, Bar Council of India is vested with the duty, or it has to function, its function is none other than to dispose of such matters which are referred to it by the State Bar Councils concerned. Next, to promote legal education. First one, before that, what we have dealt is to bring about legal reformation. Reformation through law, reformation in the society by making certain law or advising for making of certain laws. Here, what we are referring to is none other than to promote legal education, and also, which is very important, to lay down standards of legal education. What should be the standard of legal education? What all subjects has to be introduced? What should be the standard of legal education which shall be followed by the upcoming students, so upcoming lawyers who are students who are studying law in the concerned universities? So again, to promote legal education, to lay down certain standards of legal education, promote as well as to lay down certain standards of legal education. Now, this is done. What? Legal education, promotion of legal education and laying down standards of legal education are done with the consultation, in consultation with the universities. In consultation with the universities in India which are imparting legal education and the concerned state bar councils. So, legal promotion of legal education, laying down standards of legal education shall be done in accordance or after making consultation with the concerned state universities or state bar councils. Now, this is very important with regard again to recognize universities. Bar Council's function is also to recognize universities whose law degree shall be a qualification for enrollment. Now it shall recognize Sri Venkateswara University, Madras University, or any other universities which are imparting law degrees, and these recognition will be given for as a recognition to recognize you, recognize that particular degree to become qualified lawyers, so that you will enroll in the state concerned state roles as a advocate. Now the Bar Council of India is vested with the authority to inspect such universities. Inspections shall be conducted by these universities, this Bar Council of India, to these universities, as well as State Bar Council also is vested with these universities in the authority to inspect these universities and colleges. Okay, so Bar Council of India, in order to implement this, they will inspect these universities, direct the State Bar Council to visit and inspect these universities for the purpose of imparting good legal education, and whether they have laid down that particular legal standard which has been directed by the Bar Council of India. Now, even though this is said, please note down a case law. Bar Council of India versus Board of Management, Board of Management, Dayanand College of Law. Ananda alla, Dayanand College of Law. Ananda alla. DAYA Daya Anand, AND. Dayanand College of Law. Okay. Bar Council of India versus Board of Management, Dayanand College of Law. 2007, Volume 2, SEC 202. Control of legal education. Please write a hyphen, control of legal education. I will go through the important part of the decision. Control of legal education. Okay. Now it has been pointed out by the Supreme Court in this particular case that having regard to section 7(1)(h) and various other sections also which provide for imparting for legal educational reformations, which are subsequently section 24, section 49, 1AF and 1D of the Advocates Act, and rules also subsequently, other rules also laid down by the Bar Council of India. It is clear that, please listen very carefully, it is clear that though the Bar Council of India may not have been entrusted with the direct control of legal education, that is, Bar Council may not be having an authority to directly control the legal education. Why? Because this is a function which is entrusted to the universities. Directly influencing or directly doing whatever is necessary for legal education is only entrusted with the universities, and this function is not directly vested with the Bar Council of India. Even though that is not directly vested with them, the Bar Council of India retains adequate power to control the course of study. Despite they have no direct control, they have adequate power to control the course of study in law, the power of inspection, the power of recognition of law degree, and the power to deny enrollment to law degree holders unless the universities from which they pass out is recognized by the Bar Council of India. Okay. Even though they cannot lay down the standards which are to be done by the students in the universities through their legal educational aspect. Now these universities has to be recognized by Bar Council of India. Unless until it is been recognized by the Bar Council of India, you are not allowed to enroll in the state role. Okay. Next is other functions of Bar Council of India under this particular section 7 is to conduct seminar talks on topics which are highly important jurisprudential in nature, which shall include publishing journals, papers for legal interests. So it is also one of the function of the Bar Council of India to conduct seminars with regarding to which are all connected to legal matters. Again, it is coming within the purview of legal reformation, to bring up a legal reformation. To organize legal aid to poor, we have a legal aid committee also formulated, for which yet Bar Council is vested with the function to give legal aid to the poor. Also keep in mind that we have a separate committee formulated for this, legal aid committee. Next, to recognize on a reciprocal basis foreign qualifications in law obtained outside India for the purpose of admission of an advocate in India, which we have seen in section 47, if I am not wrong, 47, reciprocity, which we have seen yesterday. That 47. So on the basis of the reciprocity, it will recognize universities or foreign degrees in order to allow them, those citizens, to enroll in India. Then manage and invest the fund of Bar Council of India. Obviously, auditing will be there, accountant, officers, staffs will be there for the Bar Council, as it is a body, a statutory body, a corporate body, which is a artificial person having its own common seal, which can acquire property, which can sue and be sued in its name. Hence, it is also has to manage a fund for its own purpose. It is also another function which is performed by Bar Council of India to provide for election of its members who shall run the Bar Council. Again, election also be conducted. It is also another function of the Bar Council to conduct election so as to run the particular statutory body, which is none other than the Bar Council of India. These are the few functions of Bar Council India. Please refer to section 7 fully and section 6, which is dealing with the functions of State Bar Council. And this is again going to be asked as part B question. What are the functions of State Bar Council? What are the functions of Bar Council of India? How Bar Council of India is formulated? What is the nature of the body that is none other than the Bar Council of India or the Bar Council, State Bar Council also. Now, as this is completed, we will go to another topic, which is coming within the purview of section 16 of the Advocates Act. Now, section 16, chapter 3 of the Advocates Act, admission and enrollment of advocate. Section 24 we have seen. Now, section 16 of the Advocates Act, which is coming within the purview of chapter 3, section 16, titled as Senior and Other Advocates. We have seen prior to the culmination of the 25 Act of 25 1961, there were muktars, there were lawyers, there were vakils, there were barristers, solicitors, advocates, attorney generals, etc. Ultimately, when Advocates Act of 1961 was established, we have come to conclusion that there is only one class, that is known as advocates. Section 16 says there are two classes of advocates. Note it down. There are two classes of advocates. There are two classes of advocates. First, they are none other than senior advocates. Senior advocates. And other, second is, there is no such thing as junior advocates. Other advocates. There are no such thing as junior advocates under the Advocates Act. There are only two classes of advocates. One is senior advocate and the other is other advocates. Now the question arises, senior advocates means who? Yeah, my senior under whom I am working. No, it is not so. We are not referring in here in that particular seniority under whom I am working, maybe my senior of my college, likewise, who has been practicing for 10 years. Maybe he may be practicing for 10 years. We are not referring for 15 years or 24 years. We are not referring here with regard to that particular senior. We are here referring to those seniors who are designated seniors. They are designated seniors. Many of you might be familiar of them, designated seniors. Their robes, gown, robes will be different from that of ours. Understood? The robes which is worn by designated seniors are different from ours for them to be identified. Their robes are similar to the robes which are worn by High Court judge or Supreme Court judge. Understood? Their sleeves will be lengthier, not full sleeve. Upper part will not be there, lower part will be there. Okay, and behind the robes there will be a square portion, which is a square portion of cloth extension. I think that's it. That's it. We used to have a joke around them. That is, that big sleeve of cloth is none other than a zip of pocket in which you can give money. I don't know why that is. It is there. That is the difference. We don't have that. We are not grown to that level to get money. So that is there. So designated seniors. Now, who is giving them this designation? That is a question. Second thing, we have studied there shouldn't be any differences or discrimination for the so-called advocates. We are all one. And why this classification? Is this a reasonable classification? Is this a reasonable classification? Is there a valid objective behind this classification? Etc. are to be addressed in this section. Now, section 16, as we have seen, as I've told you, there are two classes. One are senior as well as other advocates. Now, who can be designated as a senior advocate is a question. Now, the answer to which is provided under this section is that an advocate may be designated as a senior advocate with his consent. Whose consent? If, say, for example, I have an experience in the bar for 10 years and I am possessed with certain other qualifications, which I am going to tell you. Then, with my consent, I will be appointed as a senior advocate. So, if I don't want to be a senior advocate, then I might not be willing, then I would not be appointed as a senior advocate. Who is the appointing authority? The Supreme Court or the High Court. They are of the opinion that by the virtue of the ability of that particular person, for example, me, by the ability of that person, I possess certain abilities. With my consent, I will be, say, for example, I am deserving to be appointed as a senior advocate, whereby I am a distinct person from others. Why? Because of those abilities which I am possessing. What kind of abilities? Please, you may note it down. The abilities such as standing in the bar, say 10 years maybe. Age is not a factor. Age is not a factor herein. Maybe I am not 50 years. Maybe I am not 60 years. But if I have an experience of standing in the bar of 10 years, I might be considered as a designated senior. Need not be, I need to grow white hair for that purpose. No. My ability or my standing in the bar, one, I have a special knowledge in law. I have special knowledge in some particular part of the law or in the law generally. Experience in law. These are all calculated by the Supreme Court or the High Court. Finally, they find it that I am deserving to be designated and distinguished from those others. Hence, I will be appointed as a designated senior advocate. Now, there will be a permanent committee also. Okay, there will be a permanent committee who would recommend the name by the Bar Council, who will recommend the name to the concerned High Court or the Supreme Court, and according to which the Supreme Court or the High Court may take such decisions. Now, with regard to the question of classification, with regard to the question of reasonable classification, valid objectivity of this particular section, of this such a discrimination, whether is it discriminatory or is it a reasonable classification, was answered by the Supreme Court in, note it down, Indira Jayasingh, Jaising, Indira Jayasingh versus Indira Jayasingh versus Supreme Court of India, 2017 in bracket, 2017 in bracket, volume 9 SCC, Supreme Court cases, SCC, page number 766. Okay, before coming into the concerned answer to the question of classification, which is reasonable or not, this in this, should I repeat the citation? Citation repeat. Before coming into the answer to the question of reasonable classification, the court has pointed out in this case, there is a uniform guidelines to be followed. There should be a uniform guidelines which should be followed throughout India in order to designate a person as senior advocate by the High Court as well as the Supreme Court regarding the procedure of designation. Okay, uniform standard should be laid down, and this is to be seen by the permanent committee which is laid down, which is made out by the Bar Council concerned. This procedure must be to ensure strictly, okay, strict scrutiny should be done with regard to this criteria, which is followed uniformly with regard to the quality they are possessing, the qualification they are possessing, and the best and the deserving persons should be only be designated as designated seniors. Quality, say for example, one advocate who is without any reasonable justification prolonging his own cases so as to provide injustice to the other party, he knows he will not win the case. Whether he is a deserving person, that becomes a disqualification. That should also be considered. So certain standard or criteria has been laid down. We need not go into depth. Okay, and there should be no scope of any doubt or any disqualifications which are possessed by that particular person. There shouldn't be any doubt on the other advocates. There shouldn't be any disqualification which is being possessed by him. He should be a person with a high moral turpitude, professional dignity. Okay, and the norm of 10 years may be considered to be as a term of standing of practice, and age factor need not be a factor to be considered here. That is what I told you earlier. Okay, these were certain other points which could be said to be as a qualification which is possessed by the so-called senior advocate, whom they are being appointed as senior advocates by the Supreme Court or the concerned High Court. Now coming to the answer to the question of reasonable classification, again, Indira Jayasingh, Supreme Court of India, 2017, volume 9, Supreme Court cases, 766. In this case, which you have just now written, the court has pointed out, verdicted that the designation of some selected advocate as senior is a reasonable classification. It is a reasonable classification. There is a valid objective behind this classification also. It cannot be an unreasonable classification. It is a reasonable classification, and this classification is backed up with a valid objective. then the objective of the said classification is none other than to recognize a person's quality, a person's quality, a person's merit, a person's ability, a person's skill and experience which he possesses in law, his standing as an advocate, etc. And this seniority can also be seen in every professions, not only advocates, but every other professions also. This seniority can also be seen. Then the talent and special qualities of a person which is proved over a period of time is again reasonable. Then this objective would ensure the value of legal system. Hence, section 16 is the designation of lawyers under section 16 passes the test of reasonable classification. Okay, hence it is constitutionally valid. So it is a very important case. Please refer to the case if you want to know further about this classification of lawyers into two under section 16. Now we have a right of pre-audience. Time is 11:12. You can have a break.
Good Anjay. Right? Yeah, please. So, yesterday we have seen the appointment of an arbitrator, right? Today we are going to see the arbitration process, how the arbitration process goes on till finalization of the award. So normally what happens is parties are free to agree the procedure and they can determine procedural rules. Parties are free to determine. Why? Arbitration agreement has been acted upon by the consent of the parties. Now, you have constituted the arbitration tribunal. Now, the arbitration tribunal, yesterday itself I told, don't munch anything in the class. It's very distracting to me. என்ன உன் பேர் என்ன? Shyam? Right. No issues. When you come for Viva, I will see. Don't worry. You will get more marks for this indiscipline. Right. No, certain things you are all grown-up children. I don't know why you are behaving in this. There is some etiquette attached to some profession, some things. Right. Now, the arbitral tribunal will decide two types of issues first. One is procedural issues. Second one is substantive issues. First they have determined. First one is procedural issues they have to determine. That means how the arbitral tribunal is going with the procedure. What is the procedure for conducting the proceedings? What is the length of the proceedings? How it is going to conduct the entire proceedings? It will be decided in the procedural issues. Now, after deciding the procedural issues, they will go with substantive issues. You know, substantive issue determine the legal outcome of the decision. You understand? You know the procedural laws and substantive laws. Substantive law means it creates some rights by which procedural law is going to enforce your right. Here also, arbitral tribunal will decide two types of issues. One is substantial issues, another one is procedural issues. First one, procedural issues. Here, parties are given autonomy to decide the issues. Why? Arbitration entirely is based upon free will of the parties, right? But merely based upon free will of the parties, it cannot go beyond the general laws of India. You understand? Merely whatever that has freedom that has been given to you, it should be exercised within the parameters of law only. Now, once the arbitral tribunal decides the substantive issues and procedural issues, then it will go for the conduct of proceedings of arbitration. Normally, these issues are generally influenced by the place of arbitration where you are going to conduct. Whether it may be procedural issues or whether it may be substantive issues, it will be determined indirectly by the place of arbitration in which you are going to conduct your proceedings. Normally, arbitrator's decision is considered to be final and binding on the parties. Understand? It's considered as final and it is binding on the parties. Now, in some circumstances, you can set aside the award under section 34 of Arbitration Conciliation Act. You have to make an application to the courts, district courts, for setting aside the arbitration award. Straight away, arbitration award cannot be set aside unless and until it is patently illegal. Unless it is patently illegal, it is erroneous, or it is contrary to any provisions of the law only. Mere procedural infirmities does not displace the finality of the award. It should be patently illegal, erroneous. It contravenes any provisions of the law only. Now, you know the difference between 1940 Act and 1996 Act. In 1940 Act, more judicial intervention is there. In 1996 Act, yes, there is judicial intervention is there, but only to a limited extent, right? Now, you have set the terms of reference of arbitration. Remember, any arbitral procedure, it cannot go beyond substantive laws of India. Number one, it cannot go beyond substantive laws of India. What are substantive laws? Indian Contract Act, IPC, Transfer of Property Act. It cannot go beyond substantive laws. Merely parties are free to determine, they cannot determine by bypassing or surpassing any law, first aspect. So the entire arbitral procedure should not go beyond substantive laws. Second one is, it cannot go beyond Arbitration and Conciliation Act. Second one. Third one is, it cannot go beyond section 28(3) of the Arbitration Act. Section 28(3). This section 28(3) speaks about terms of contract and general usages in respect of that transaction. Terms of the contract and general usages in respect of the transaction. What is meant by transaction? Have you heard this word? In Evidence Act it has come. What is meant by transaction? So again, if there is no any law but there is some usage of customs and trade practices, the arbitral tribunal has invariably followed that usages in the transaction. ఆ ట్రాన్సాక్షన్లో ఏదన్నా ఒక యూసేజ్ ఉంది అనుకోండి, 200 ఏండ్లు 300 ఏండ్లు ఫాలో చేస్తున్నారు అనుకోండి, with respect to the place of arbitration, you have to invariably follow. That's what section 28(3) speaks about. So every arbitral tribunal cannot go beyond substantive laws, it cannot go beyond Arbitration Conciliation Act, it cannot go beyond section 28(3) of the Arbitration Conciliation Act. These are the three things. Next one is, yes, now we have decided the procedural issues, substantive issues. Now we have to commence the arbitration. Next step is commencement of arbitration. Right. Commencement of arbitration is nothing but it is the evidence of the dispute. Unless and until dispute is there, you cannot come for arbitration. That means the commencement of the arbitration, what it signifies, there is evidence of the dispute. Second one is legal consequences or legal implications of the dispute also. You understand? First, there is existence of dispute. Once award has been passed, what you are going to do? You are binding on the award. That means legal consequences arise. நீ ஆர்பிட்ரேஷனுக்கு போனேன்னா மீனிங் என்ன? டிஸ்பியூட் இருக்கு. டிஸ்பியூட் இருந்தாதான் நம்ம ஆர்பிட்ரேஷனுக்கு போக முடியும். டிஸ்பியூட் வந்தா விட்டு நீ ஆர்பிட்ரேஷனுக்கு போனா விட்டு அது லீகல் கான்சிக்வன்சஸ் என்ன? அவார்டு கொடுப்பா. அவார்டு நீ ஃபாலோ பண்ணணுமா பண்ணக்கூடாதா? பண்ணணும். Why? By the free consent you have gone to the arbitration, you are bound to follow the award. Right? Then if you don't agree the terms and conditions of the award, and if you go and challenge the award, the court says no. There is limited intervention. That is only erroneous, patently illegal. If it contravenes only any provisions of the law, only I can set aside the award. For any reason, if you don't like the award, if you come to me, I cannot set aside. We have to prove beyond the reasonable doubt. You understand? So the existence of the dispute itself that implies commencement of the arbitration, and you are accepting for the legal consequences, that is award is going to be passed, you are accepting the award. Right. Now assume that the arbitral proceedings has to start. First, they will issue notice of arbitration to other parties. Notice of arbitration. Now, in this notice of arbitration, you need not state your full statement of claim. మీరు నోటీస్ ఇచ్చినప్పుడు normally what you are going to file in the arbitration, statement of claim, statement of defense. So first you are normally in civil suits what you are going to do? If you are filing a plaint and summons should accompany what? Plaint. Summons should accompany plaint. Here also, when you are invoking the arbitration agreement, you are filing statement of claim, but in fact, it does not contain full particulars of statement of claim. எனக்கு இந்த காசு வரணும், you are claiming that thing, I want this money from that person. Why? There is some dispute is there, breach of contract is there, so you are claiming that amount. In civil suit, written statement is there. Here, statement of defense is there. Right. Now, first you are issuing notice of claim. It's not a statement of claim. It's a notice of claim you are going to issue. Right. With limited access to the claim. This is the claim I am going to claim against you. Now, subsequently, in this notice also, you have to invariably mention nature and circumstances of the contractual arrangement, breaches and relief sought. ఈ claim లో మీరు ఏం అడుగుతున్నారంటే, this is the breach you have done, this is the contractual breach that has been done, and relief sought also you are going to ask. In plaint also you are asking prayer, that is known as relief. Prayer kepanam court, let is therefore prayed that this court may be pleased to give this so and so relief. In statement of claim also, notice of claim also, you are asking, this is the relief I am claiming against you. Right. Now, first duty is what is to be done for the conduct of this arbitration procedure. First they have to determine. Subsequently, what happens is, you are claiming the remedy also. So once you are claiming the remedy, now here you are going and filing a detailed statement of claim. ఫస్ట్ లో ఏమో ఒక నోటీస్ ఆఫ్ క్లెయిమ్ ఇచ్చి మినిమం నాకు ఇవన్నీ ఉంటుందని చెప్తారు. ఇప్పుడు ఏం చేస్తున్నారు? ప్రొసీజర్ స్టార్ట్ అయింది. నౌ ద ఆర్బిట్రల్ tribunal will receive your statement of claim as well as statement of defense. Now, if the claimant fails to communicate his statement of claim in accordance with the time frame, if the claimant fails to communicate his statement of claim in accordance with the time frame set by the arbitral tribunal, what happens? His claim will be dismissed. His claim will be dismissed. Why? You yourself filed statement of civil court ku poi plaint file panni, if plaintiff absent, what happens to the suit? Suit is ex parte, dismissed. If the defendant absent, what happens? Ex parte. Right. Here also, if the claimant fails to file the statement of claim within the prescribed period that has been prescribed by the arbitral tribunal, then the arbitral tribunal shall terminate the proceedings. ఇక్కడ ఏమి ఆర్డర్ పాస్ చేయరు. They will terminate the proceedings. Right. Now, on the other hand, if the respondent fails to communicate the statement of defense within the time agreed, the arbitral tribunal shall continue the proceedings. It will continue the proceedings. Who is failed to file the statement of defense? Respondent. Now, merely respondent has failed to file the statement of defense, that does not imply that he is accepting all the claims. You understand? Statement of defense, our respondent file panla, our file pannatanaல அவன் claim எல்லாம் கூட accept பண்ணிருக்கான்னா, it's not so. You understand? If the respondent fails to file the statement of defense it does not imply that he has accepted all the admissions that has been made in the statement of claim. Right. Now, terms of reference includes names and addresses of the claimants, names and addresses of the petitioners, summary of the parties' claims and the relief sought, list of issues, so on and so forth. Right. Now, first, the arbitral tribunal has to decide on the issues of procedural orders. First, they have to make the procedural aspects first. Why? Unless and until you determine the procedural aspects, you cannot go into the veracity of the main claim. Procedural aspects ante enti ante ekkada కూర్చోవాలి, ఎంతమంది కూర్చోవాలి, what is the time limit to conclude the proceedings, when award has to be passed. These are the procedures that has been entrusted with the arbitral tribunal. That means what is the seat of arbitration, what are the arrangements, so on and so forth. Normally, procedural orders cannot be challenged in the courts. You understand? They are merely procedural infirmities only. Infirmities. Anna, some defects is there. The defects can be cured. Defects can be cured. Procedural defects can be cured. Substantive defects cannot be cured unless and until set aside by the higher courts. There is a lack of procedure only that can be cured by correcting the procedure. Right. Next, length of arbitration. Length of arbitration. How long this arbitration should go on. Right. Again, here parties are free to determine the length of arbitration. Here, there is one technical aspect is there. You know law of limitation. What is law of limitation? Huh? Here, if you file an arbitration application, limitation period stops. Normally, మీరు ఒక సూట్ ఫైల్ చేయాలి. సూట్ ఫైల్ చేసిన తర్వాత అపీల్కి వెళ్ళాలి అనుకున్నప్పుడు విత్ ఇన్ సర్టైన్ టైమ్ యూ హ్యావ్ టు ఫైల్, అదర్వైజ్ లిమిటేషన్ స్టార్ట్స్. Now you filed a application before the arbitral tribunal, limitation stops here. Why? The entire period of again, if arbitration is failed, again what is your recourse? Coming back to courts. Coming back to courts. Now assume that the time period is there to come to the courts. In spite of going to the court, you went to arbitration. That period is also counted as the period of limitation. The limitation period stops there. Again, once you file the suit here in the courts, limitation period starts. Arbitration period lo limitation ఏమవుతుంది? స్టాప్ అయిపోతుంది అక్కడికి. మళ్ళీ మీరు ఇక్కడికి వచ్చారనుకోండి, మళ్ళీ what happen? Limitation starts now. Limitation extinguishes your rights. You understand? Limitation extinguishes your remedy but not your rights. And అర్థమైందా? Limitation extinguishes your remedy but not your rights. For example, you have taken a promissory note. What is the time limit for filing a suit for promissory note? 3 years. 3 years. You have given the money. That is fact. If you don't go after 3 years, within 3 years, your right of remedy is extinguished. கோர்ட்டுக்கு போன கோர்ட் என்ன சொல்ல, நீ காசு கொடுத்தது கரெக்ட் தான், பட் கோர்ட்டுக்கு லேட்டா வந்த, உன் ரைட் இருக்கு, ரெமெடி கிடையாது. You understand? Your right is there, but I can't give you any remedy. So here, once if you file an application before the arbitral tribunal, limitation period stops. Again, once if you come to the courts, again limitation period runs. Right. Now you have to decide the time limit for arbitration. What is the length of arbitration? 60 days after the close of proceedings or 9 months. Again, you are free to determine within a reasonable period. What is reasonable? Again, it is depends upon the facts and circumstances of the case. But if you go for institutional arbitration, it will be determined by the rules of that institution. I have told what is meant by institutional arbitration. International chambers of commerce. We can go for big arbitration. In spite of they are going for private adjudicatory process, they will go before and file application before the institutions. Then they will be having certain time rules, time frame. Within that time frame, they will decide. Now, you are filing statement of claim, you are filing statement of defense. Now here, you can also file statement of counter claim also. You can file, you know the meaning of counter claim. Enna counter claim anna? Set of counter claim, CPC la undadu. You can claim set off, you can claim counter claim also. So normally you have to make certain submissions in the statement of claim and statement of defense, namely the facts. First one, you have to mention the facts supporting the claim, defense or counter claim. First enna pannano, your facts supporting your claim, counter claims. Next one is legal issues in dispute. What are the legal issues in dispute? Right. Second, you have to frame your legal issues. Third one, what is the relief or remedy sought? What is the relief or remedy sought, you are going to ask. Fourth one, contentions about the grounds for jurisdiction. What are your contentions for the grounds about jurisdiction? Next one, submissions concerning the law governing the arbitration. What are your submissions with respect to the law governing the arbitration and the law applicable to the substance of the dispute also? What is the law applicable to the substance of the disputes? Right. Next one, legal argument. Legal argument. Right. Next one, detailed specification of amount of damages claimed. Detailed specification of amount of damages claimed. Here, while submitting your arguments, again, you have a choice. Either go for oral admissions only or by written documents, written submission or by way of mixed. మీరు చూస్ చేసుకోవచ్చు. ఓరల్గా మీరు చెప్తారా, ఆర్బిట్రల్ అక్కడ వెళ్ళి, లేదు డాక్యుమెంట్స్ ద్వారా మీరు చెప్పవలసింది చెప్తారా, లేదు యు ఆర్ రిసార్టింగ్ టు both. So next, last one is reimbursement of arbitration expenses. Request for reimbursement of arbitration expenses and counsel fees. Now you have submitted oral documents, everything. Now the arbitral tribunal will appreciate the evidence. Now it is going to appreciate the evidence. Evidence illada panna mudiyadu. Ippo evidence edukono. Now you have take the evidence. Now you know arbitral tribunal is not bound by Evidence Act. Arbitral tribunal is not bound by CPC. Then it is very crucial for the arbitral tribunal how you are going to determine the evidences. Now you are going to submit statement of facts. statement of facts. There is a wonderful concept in Evidence Act. Facts which have to be proved, facts which need not be proved. Again, what are the facts we are going to prove, and what are the facts it is a fact which need not be proved. అర్థమవుతుందా? కొన్ని ఫ్యాక్ట్స్ ఉంటాయి, అది కొన్ని ఫ్యాక్ట్స్ ప్రూవ్ பண்ற தேவை கிடையாது. என்னது? ఏమది? Facts which need not be proved. You know what is meant by fact? ఏం ఫ్యాక్ట్ అంటే? You have to prove two things, fact and law. Suppose if you are resorting on a foreign law లో ఇలా ఉంది అని మీరు ఆర్బిట్రేషన్ వచ్చి ప్రూవ్ చేశారనుకోండి, అది ఫ్యాక్ట్ కింద ప్రూవ్ చేయాలా లేకపోతే దేని కింద ప్రూవ్ చేయాలి? It should be proved as a fact. Certain things will be there if you are resorting to foreign law. Why? These are not bound by the strict procedures of Evidence Act, strict procedures of CPC. Right. Now they are free to agree even how the evidences are going to be taken also. It is depends upon the consent of the parties. Right. Now again, if there is a conflict with any mandatory provisions of the law, then how you are going to resolve this conflict? Right. Now we have seen the different arbitral proceedings, how it is going to be commenced. First, they have to decide on substantive issues and procedural issues. They have to decide the procedural issues first. Subsequently, statement of defense, statement of claim, then how they are going to take appreciation of evidences. Now, assume that subsequently everything has been done, they will pass an arbitral award. Right. Now, once arbitral award has been passed, arbitral tribunal becomes functus officio, non-functus officio. అంటే ఇంకా వాళ్ళ రోల్ ఇంకేం ఉండదు. Once they have passed arbitral award, then it is up to the parties for the enforcement and execution of the awards. You understand? Different types of awards will be there. Here, section 27 comes into picture. Section 27. Why? Parties, section 27 speaks about judicial intervention of the courts in arbitral proceedings. Judicial intervention. For example, you are appreciating the evidence before the arbitral tribunal, both parties will come to the arbitration tribunal. Right. One party is asserting that there is some evidence in the custody of that party. ஒரு பார்ட்டி என்ன சொன்னா, இந்த டாக்குமெண்ட்ஸ் எல்லாம் எனக்கு வேணும், இதெல்லாம் இம்பார்ட்டன்ட், இவன் அவன் கிட்ட இருக்கு, நீங்க வரவிச்சுக்கோங்கன்னு சொன்னான். யார் சொன்னா? Assume that A has told. Now B is telling, it is there, என் கிட்ட கிடையாது, என் ஃப்ரெண்டு கிட்ட இருக்கு அதெல்லாம் சொன்னான். He told, it is with my friend. Now he is not a party to the arbitration agreement. அவன் பார்ட்டி கிடையாது. அப்போ arbitral tribunal will issue notice to third party. Notice issue பண்ணா விட்டு அவன் என்ன பண்ணுவான் தெரியுமா? கோர்ட் சொன்னாவே நான் கேட்க மாட்டேன், அவன் எவன மூணாவது நோட்டீஸ் கொடுத்தா நான் ஏன் கேட்பேன்? ஈவன் கோர்ட் இஷ்யூ டிக்ரி, I don't obey the decree. Some other person to which I am not a party to the agreement, it's a private adjudicatory process. He is issuing notices to produce that. Now, arbitral tribunal, I am not party to the arbitration agreement. I am a third party. He is asking me to produce certain documents, records within my custody. I don't give. Now, na kudukka maten solluvan ivan. Then you have to file one application before the arbitral tribunal. Arbitral tribunal will seek the assistance of the court under section 27. Now arbitral tribunal will go to the courts. They will seek the assistance of the court. என்ன சொல்லணும்னா இந்த டாக்குமெண்ட்ஸ் எல்லாம் அவங்கிட்ட இருக்கு, அவங்கிட்ட right, AC is going on, so sleep is coming. No issues. Sleeping is your fundamental right. Yes, sleeping is your fundamental right, subject to reasonable restrictions. Right. Now, under section 27, the arbitral tribunal. தூங்க ஏந்து ஆயிப்போச்சா? தூங்குன ஆளுக்கு தெரியும் யார சொன்னேன்னு சொல்லு. Right. No issues. Now, they file an application under section 27. Now, who file application? Arbitral tribunal in the court under section 27. That means judicial role will come into picture. Merely arbitral tribunal has made an application. It is not duty of the court to simply pass an order on section 27 application. நீ application போட்ட உடனே நான் order pass பண்ண மாட்டேன். Again, what the Supreme Court said is, you have to apply your minds while making an what is called order on section 27 application. So simply you are filing an application the district court under section 27. போட்ட உடனே yes அனு சொல்லக்கூடாது. You have to go into the merits of the case. Right. Now assume that everything, every procedural formalities has been completed, then subsequently award has passed. Once award has been passed, arbitral tribunal becomes functus officio. That means it is non-est in the eyes of the law. This award operates as a res judicata in other proceedings. This award operates as a res judicata in other proceedings between the same parties. Right? We will see different types of awards next class. Got something today? Right. Good afternoon, class. So last class we have discussed about yes. Today we are going to discuss so last class we have discussed about organized crime, then narcotic substance. Yes or no? Yes. So today we are going to discuss about fraudulent trade practice and adulteration of food and drugs. What is fraudulent trade practice? Fraudulent trade practice. So whenever you use some decisive method, fraudulent method to or unethical method for your benefit of your trade, that is a fraudulent trade practice. Let I have a company, oil manufacturing company, mustard oil, not mustache, mustard. So, so if for benefit of my company, I add some other seeds, low quality seeds to my mustards and produce the oil, I use the unethical way or trade practice for my own benefit. So that is example of the fraudulent trade practice. So basically in Consumer Protection Act, you find out the what is the definition of unfair trade practice. 2R. What it says? Unfair trade practice means a trade practice which for the purpose of promoting sale, use of or supply of any goods or for the provision of any service adopt any unfair means or illegal means, that is unfair trade practice. They have given the list. When you said that your ingredients are these, but there is no ingredient of that thing or substandard ingredient is present in your quantity. Most of the cases, if you have taken ice cream, it is basically not ice cream, it is the frozen dessert which contains the vegetable oil, and in ice cream vegetable oils should not be contained. So they, in name of ice cream, they give you the frozen dessert. Some says if you take our product or claim that if you take our product you become a Shaktiman. Yes, some drinks are there which says gives you wings. So originally you cannot have the wings. That are the unfair trade practice. So yes, but the spelling of wings after the case they change the spelling of wings. That are the some claim that our product was tested by this company or this department which is comes to the standard and it is useful for this thing, and they don't make any type of affiliation, make any type of
checked by that company. That is an unlawful trade practice. There is so many lists are given in that 2R, which comes under your unfair trade practice. It is just an example what I have given. So for fraudulent or unfair trade practice, there are too many examples we can take. Adulteration, substandard things, false weight, or you have to, or pricing high for a substandard thing, misleading advertisements. These are comes under your trade practice. So how to prevent that thing, or what we have statutes to prevent this unfair trade practice? First, our general penal provision, IPC. IPC is 272, 273, 274, 5 and 276 deals about the adulteration of food and adulteration of drugs. If you go to 272 and 273, it deals about the adulteration of food. So basically 272, whoever says about those persons who adulterate the food or make the food noxious, it gives a penal provision of 6 months of imprisonment and fine for that adulterator. As I said, if I add some degraded or substandard seeds to the mustard seed, whatever you pronounce it. Sorry for my pronunciation. So I added substandard seeds in my mustard seed and make a adulterated mustard oil. 272 punishment. 273 punishes those persons who sell that adulterated food knowing that it is a substandard thing. My mustard oil, I am a producer, he is the retailer. He knows that I have selling low grade. For the benefit, he buy that thing and sell those things. 273 punishing. Same punishment, 6 months and or fine. Now, this is the part of food. Yes. Let that example of wine. Desi country made liquor. So sometimes what happened? For due to that wrong procedure, it become poisonous. And by drinking that, some people die. So here, not only for that person punished for the adulteration, but also for the cause of death of that person. That means culpable homicide also they are going to get punishments, because they know if they follow the wrong procedure to making that liquor, it is poisonous, and those who are getting consume that thing die. He has the knowledge, he has the so culpable homicide. Now come to drugs, medicines basically, not yesterday's drugs. Okay. So here also, who adulterate a drug to reduce the operational value, or knowingly that it is not that much effective to your body, 274 gives the punishment. About 6 month imprisonment and fine up to 1000 rupees. Here another person added those who refer to that medicine, basically the doctors, who knowingly that it is not to that standard, that have an operational value or has that much effect to the patient's body. 275, they get the punishment under section 275. Same punishment, 6 months and 1000 rupees fine. Now the seller, 276. That means you know that this medicine is only just a, what you call, placebo, or that is not so effective to that particular disease. By that also you are selling that thing, or you have the knowledge it is a substandard or a some contrary effect to your body. 276. Yes, if you sell it out knowing that its expiry is also gone, you can come under this thing. Basically, what that adulteration of drugs is, when you are selling, producing, or referring someone a substandard thing, knowing that it has a less operational value or efficacy or efficiency of that thing is reduced or has some alternate effect to your body, that comes under this thing. So if expiry date is gone for that thing, if once that medicine was expired, that might be cause some adverse effect to your body, so it be comes under this thing also. If someone die, then you have to go to the ingredients of culpable homicide and or murder. If satisfy, what is satisfying? Culpable homicide, then culpable homicide. Yes. So basically, when you are going to IPC, then you have to calculate that what is intention, what is his knowledge. He has knowledge about that thing. He has intention to kill that thing. As per that 299 and 300, you have to calculate that what punishment he is going to get. But for selling, for referring some, if someone selling you that expiry date medicine, comes under this thing. So after that also, after IPC, there are too many acts. Food Adulteration Act 1945, 2006, Food Safety and Standard Act. These are come to prevent the adulteration of food. But as we know, still it is continuing. Whatever you are eating outside, it is not up to that mark which is beneficial to our health. It has the some substandard material we get. Yes or no? So this acts brings only a little bit check to the adulteration of the foods. Not that much effect. Only effect when we become conscious what we are taking, where we are taking our food or medicine. So these are certain adulteration food acts which is not so much necessary, but the necessary part is what is your unfair trade practice, what is that, where we can, how we control it, and what is the punishment, where is the punishment. As I said, in IPC, in Food Adulteration Act, Drugs Control Act, like that you get the punishments and check of that thing, right? Yes or no? Now come to crime, to the professionalism. So what is crime in professionalism or crime in professions? Now first, what is profession? Any type of job, service, we can say it is a profession. That means where you use your skill to do that job or service. It is a profession. So when a person, while doing his profession, does some crime or illegal act, that becomes a professional crime. As I am a lecturer here, without attending the class or without taking the class, if I take classes in some private coachings, that is my professional crime. Some doctors who has government doctors, because of more financial gain, they go to some private hospitals without attending the patients in the government hospitals. That is their professional crime. So what are the basic elements or what are the criteria to fulfill these professional crimes? Can you get any idea about that thing from these two examples? First, that person has qualification to do that art, practice, or whatever business, job, whatever you can say. Second, he has a particular skill over that or has a expert over that thing or has a certain knowledge over that job. In that exercise or in that job, in that service, that job required a certain ethical value, and ethical value and that person, next one, that person violate that ethical values or don't follow that values. Yes or no? So these are certain criteria where we can say if these things happen, first of all, that person has a qualification to do that job. Second, he has particular skill to do that thing. And in that job or service, there is some ethical values or some positive values to do that job. Last one, he has broken or violated all this. Basically, the last one, the ethical values. Take example of advocates. What is, we are all are going, you are going to be advocate. So what is the ethical value of an advocate? To follow the law, to respect the court, to respect his clients. So all the code of conduct are given in Advocates Act 1961 around. Sorry, 61. So they, in that act it says what is your code of professionalism, how to behave to the seniors, how to behave with the juniors, how to behave in the court. In your that moot court, madam will discuss with you how to address the court, how to deal with the clients. That is your professionals. You take money from your client and don't do the job, you have violated your ethical values. Because if you take money or consideration for that legal service, you have to follow that thing. It is your professional crime. You go and disrespect the court. You say that, no, no, sir, you are wrong. This is correct. No doubt, it is in general term. No, he might be wrong, court might be wrong, and you are correcting him. But that is not the way. You have to follow a particular way to say that court is wrong. Yes. So does this service provided by the advocates comes under Consumer Protection Act? Yes, but the clients are not consumers here. They are just, you say, yes, service getter. Second one, doctors. One examples we have taking. Doctors, as I say you earlier, doctor was government posted, but he is practicing in private, or he has sending patients to a particular private hospital. Go, you cannot get proper treatment here. You go to that particular private nursing home or private hospital. Their misconduct or their professional crimes. So, whenever a patient goes to the doctor, why he is going there? For betterment of his disease, betterment of his health, and doctor undertakes, or he has on moral obligation to serve him. If he is don't follow that his, or he is not give proper treatment, then it becomes a professional crimes. Same way you can find out engineering professionals, other. So basically, what is your professional crime? Where you are in a profession and you are don't do or did not carry out that profession, or you have a lacuna to carry forward that thing, or you are doing some unethical practice over that profession. It becomes a professional crime. Advocate, doctor, whoever they are, whatever profession you are, take the name, teachers, police, if they don't done their job with a bona fide intention, or have some bona fide, or they have some malified intention to don't do that job, or for better uh, for their betterment they refer something, it becomes a professional. Understood? Any question? Hmm? So next, crime done by a human being, done against a human being, yes or no? So nowadays crime can done against animal also. Animals. So one of the most rising category against whom the crime is increasing, those are omens. Crime against women. So if we look the history, women are perhaps the most and most affected category of the crime. Every place or every stage of their life, they're facing a crime against them, starting from the mother's womb. Feticide, killing of the fetus. Okay, it's a girl child, kill him. So not starting from their birth, but prior to their birth till their death, they are facing the crimes. And for that, in India, there are various provisions are inserted. Recently, changes in 2013. Yes, after Nirbhaya Act. And some acts also inserted after 2018. Some changes bring in IPC and CRPC also to make give stringent punishment to those offenders who are done crime against the woman. So as per Indian law, what might be a crime against women? Start from the starting. Determination of the sex of the child in the mother's womb. That is a crime. Now, come to the last stage. Sati, which is very auspicious prior some decade. Now it become a crime. In middle, sexual assault, any type of harassment, dowry demand, dowry death, everything, every stage is becomes a crime nowadays. For take an example of IPC. In IPC, if it started from 354, then 354A, B, C, D are inserted in, or changes, a drastic change bring in after 2013, in 2013 amendment. Stalking, disturbing, voyeurism added in there. Next, 376, punishment for rape. A, B, C, BABs like that are inserted in first. In 2013, A, B, C, D, E are done there. Now after 2018, BA, B, so they are also inserted in IPC to check the offense against that. If you disclose the name of a rape victim, it is also punishable in IPC. Other harassments are also there. For that, harassment in the workplace, Prevention of Harassment of Women in Workplace Act was introduced. After that, Visaga versus State of Rajasthan case. Why? To check this thing. So it is our duty to give them their space, their respect. So we don't need any other act, because only by imposing certain acts we cannot check these things. We need to respect that act also. Then only these things comes down, because after 2013 amendment, does it the cases of rape decrease or increase? Increase. After that 2018 case, the rape of the childs increase or decrease? Increase. Why? Not for imposition of law, because we still don't respect the half of the population. So start to respect them from now. So for today, this is all. Thank you and have a good day. Yes, please wait for attendance. Thank you.
Please, like yesterday, girls, please leave your respective rooms. 5-year LLB general, BA LLB general, 4-2, BA LLB honors, 4-5, BBA and BCom, 4-7. Girls. Boys, also please leave. BA LLB, 4-2, BA LLB honors, 4-5, BBA and BCom, 4-7.
Yeah, last the boys are listening. Boys, they listening. अभी last clearly the right not get अभी बहुत easy Now, when you miss, you automatically go. But the other honors, afternoon, you got it from afternoon, we will. Now, already absent mark here. Where you buy it. 4 day, 9:30 to 10 automatically will consider absent. Will come. So, like, when we in the more than or will take for that will follow it. Is that then will think of will. That's not even. No, it's not. So, then stop it. You don't stop. But half an hour will be cut.
So this restart, what do you do? इंसान इधर पर्दा अभी बोला कौन सा सोलह ए ये कुछ तो सोलह
திடீர்னு யாராவது வந்துடணும் ஓகேவா? ஓகே. என்ன கீழே குனிஞ்சுக்கிட்டா? ம். ஓகே. இரு நான் இப்படி சைட்ல வந்துடு, நான் இப்படி பாக்குற மாதிரி சைடு நார்மல் கேமரா. ஐயோ
But are set now. Yes, right. So yesterday we have seen it's a procedural law. What happens next we are going to see. So what happens normally? Financial creditors, operational creditors, corporate applicant, they go before the adjudicating authorities, national, company law, tribunal. Even employees will come under corporate applicant. Even employees can also initiate corporate insolvency resolution process. Once the application is admitted by the NCLT, three things will happen. One is imposition of moratorium. Second one is public announcement. Third one is appointment of interim resolution professional. Here, interim resolution professional has certain duties. Once he completes his duties, one of the main important duty is appointment of committee of creditors. Right. Committee of creditors appoint chestadu. Why? He has to take so many decisions with respect to affairs of the company. So he will constitute a committee of creditors. Once he constitutes the committee of creditors, subsequently the creditors may continue this interim resolution professional as final resolution professional, or they may replace him also. అతన్నే కంటిన్యూ చేయొచ్చు, లేదు అంటే రీప్లేస్ చేయొచ్చు. Here he will do the process and he will submit one resolution plan to committee of creditors. Who will submit? This professional will submit resolution plan to committee of creditors. Now this committee of creditors has to accept this resolution plan. Why? Entire process is to resolve the disputes only. Right. Now once the resolution plan is approved, then it will be submitted to the adjudicating authority for approval. ఈ రెజల్యూషన్ ప్లాను సబ్మిట్ చేసిన తర్వాత it is submitted to the adjudicating authorities for approval. Right. Now here two things will happen. The adjudicating authority may approve the resolution plan as it is, or it may suggest some modifications for the resolution plan. Right. Now if the resolution plan is not submitted within the time frame, or if submitted and subsequently it has been violated, resolution plan submit చేయకపోయినా, సబ్మిట్ చేసిన తర్వాత దాన్ని వైలేట్ చేసిన, two things will happen. Then NCLT will order for liquidation and winding up of the companies. Once resolution plan is approved by the adjudicating authorities, it has to be followed. If resolution plan is not submitted within the time frame, or if submitted subsequently, it has not been followed, violated by the resolution professional, ultimately adjudicating authorities will order for liquidation. This is one aspect. Second aspect, there is another procedure prescribed under Insolvency and Bankruptcy Code, voluntary winding up of the companies. That is another arena. Straight away, the corporate debtor itself is filing the application for voluntary winding up. Here, for resolution of the disputes only, you are coming here. If the dispute is not resolved, then you are going for winding up. In second case, straight away, corporate applicant will come to the adjudicating authorities and he will file the application for winding up. So now let us see the duties of the interim resolution professional. First one, he will take immediate control over the assets of the corporate debtor. First important duty is he will take immediate control over the assets of the corporate debtor. Right. Now, subsequently, he will become the authorized representative of the corporate debtor. We have seen once moratorium has been imposed, all the powers of the company board of directors has been transferred to interim professional. Here, interim professional will become the authorized representative of the company. Now, he is going to represent the company in all forums, all adjudicating authorities, all judicial proceedings, arbitral proceedings. He is going to represent. Previously, company is going to represent in all these proceedings. Now, who is going to represent? Interim professional is going to represent the company in all the judicial proceedings, arbitral proceedings, before even any authority also. Different types of authorities will be there. For example, there is a dispute between Securities Appellate Tribunal, SEBI, there is certain disputes out there. Even certain disputes will go before Insolvency and Bankruptcy Board of India. There are certain categories of disputes where you have to approach Insolvency and Bankruptcy Board of India. From there, you have to come to NCLT. So many adjudicating authorities will be there. ఎక్కడెక్కడ ఎన్నెన్ని కేసులు ఉన్నాయో అన్ని కూడా ఎవరు రిప్రజెంట్ చేస్తారు అంటే now he is going to represent by virtue of what? There is no transfer of ownership. There is no transfer of power. Merely because NCLT passes an order and appointment of interim resolution professional, that itself is sufficient to take care of everything. Automatically, by implication of law, by operation of law, everything will be transferred to the interim professional. Now, he will take care of the company. Third one is, he will raise interim finances. Right. Again, whatever be the finances he can raise, no. Here, who is having control over the entire company means committee of creditors. అప్పుల వాళ్ళు కూర్చో ఉంటారు అక్కడ. Even if you want to raise the interim finance with respect to finance, that means you are borrowing additional amount from the institutions. Why? To set right the company. So again, even this finance creditors may infuse additional funds also. The main gamut of this procedure is to resolve the disputes, not winding up or liquidation. So what this interim professional is going to do? he will raise interim finances to set right this company. This is third duties of interim professional. Fourth one is he will appoint accountants, legal professionals, and other professionals as may be specified by the Insolvency and Bankruptcy Board of India. Now, he will maintain updated claims of the companies with respect to third parties and claims of the third parties with respect to the companies. Right, it is another duty. Now, he will convene the very important aspect duty of the interim professional is to convene the meeting of the committee of creditors. He has to convene the meeting of committee of creditors, and subsequently next thing is he has to prepare one statement of affairs with respect to the financial position of the company, that is known as information memorandum. It's very important. This is the question which is asked in your examination. Information memorandum. If you kindly remember the company law, when the official liquidator takes over the control of the company, he will prepare statement of affairs. Statement of affairs. Here, this interim resolution professional is preparing information memorandum. Right. He will prepare information memorandum. Then subsequently, he will present all the resolution plans at the meetings of the committee of the creditors. Now, these are the duties with respect to which this interim professional has to do. This duty will continue till a final resolution professional is appointed, or this person may be continued as a final resolution professional. Now, he has to prepare information memorandum. We will see what it contains. Right. It is nothing but a statement of affairs of the company. The information memorandum is the basis on which you are going to prepare the resolution plan. ఒక ప్లాన్ తయారు చేయాలి. ఇప్పుడు ఎందుకు ప్లాన్ తయారు చేయాలి అంటే to resolve the disputes raised between the adjudicating authorities. So, first one is assets and liabilities from the insolvency commencing date for ascertaining their values. So, information memorandum contains assets and liabilities for ascertaining their values. Right. Second thing is latest annual financial statements. Latest annual financial statements. He has to consolidate. Now, third one is audited financial statements of the corporate debtor. Audited financial statements of the corporate debtor for the last two financial years. Last two financial years, audited financial statements and provisional financial statements for the current year. Provisional financial statements for the current year he has to prepare. Right. Next one is list of creditors. List of creditors he has to prepare, including the amounts claimed by them. List of creditors. Here, one thing you have to remember. Normally, committee of creditors only consists of financial creditors only. Right. If the company don't contain financial creditors, then committee of creditors may consist of operational creditors. Operational creditors. Here, creditor means not only the person who has given amount to the company, even any person who has been got the amount by way of assignment, transfer, whatever it may be. Legally transfer, for example, if any person is holding a decree against the company, he will also sail along with this committee of creditors. ఎవరికైతే లీగల్ గా ట్రాన్స్ఫర్ అయిందో అమౌంట్, ఎవరికైతే లీగల్ గా అసైన్ అయిందో అమౌంట్స్, వీడు కూడా ఏం చేస్తాడు, క్రెడిటార్ రూపంలో వచ్చి అక్కడ కూర్చుంటాడు. Normally, committee of creditors is made up of financial creditors only. If the financial creditors is absent, then committee of creditors is made up of operational creditors. Now, a list of creditors containing the names of the creditors, amounts claimed by them, then amount of their claims admitted, and the security interest. He has to mention in the information memorandum. This is another duty. Next one is particulars of debt due from the corporate debtor. Particulars of debt due from the corporate debtor. Next one, details of guarantee that have been given in relation to debts of the corporate debtor. Details of guarantee that has been given. Next one is names and addresses of the members or partners. Names and addresses of members or partners holding at least 1% stake in the corporate debtor. Right. Now, names and addresses of the members or partners who is having more than 1% stake. ఏ 1% stake అంటే what is the meaning of 1% stake? How you are going to have stake in a company? Simply purchasing shares, you will holding stake. Stake means interest. Interest. If you purchase shares in a company, you will be having interest in the company. Shares always carries with its voting rights. Voting rights. Depends upon your share value, your voting rights differs. Equity shares, preference shares. Two types of shares is there. What is meant by preference shares? This stake implies not only equity shares, even preference shares also will come into this. What is meant by preference shares? అది ఎప్పుడో కంపెనీలో అయిపోయినాయి సార్. That has been over in company law, not now. The lawyer's biggest quality is forget. అవ్వలేదా? Right. Again, forgetting is your fundamental right. Yes. You see, what I observed is So many people are participating in moot courts. You don't know the how to interpret the law. அங்க போய் என்ன பேச போறோங்க? What you are going to go and argue unless and until you know about the law? Huh? How to interpret the appreciate the evidences, presumptions, may presume, shall presume, conclusive proof. தெரியுமா? May presume, shall presume, conclusive proof அண்ணா தெரியுமா தெரியாதா? தெரியாது. ரைட். தெரிஞ்சதுன்னா ப்ராப்ளம், தெரியலன்னா ப்ராப்ளமே இல்லை. ரைட். No, that is the only thing. No, at the fag end of this, you assess your capacity. Lawyers எப்படி இருக்குன்னு தெரியுமா? ரோபோ சினிமா பா, ரஜினிகாந்த் சினிமா, புக் எடுத்துண்டு டெராபைட். That should be your mind. நம்ம புக்கே எடுக்க மாட்டோம் நம்ம. రైట్. స్టేక్ అంటే అది ఏ రూపంలో అయినా స్టేక్ కావచ్చు. It may assume the form of anything. Even debenture holders is a class of creditors. You understand? Equity shares, one class of creditors. Preference shares, one class of creditors. Debenture holders, one class of creditors. So you are having not less than 1% stake in the company. You have to mention in information memorandum why you are getting amount. What is the main role of interim professional? To resolve the dispute. Dispute is with respect to money. Money. Now I am having the money. Who is having? Resolution professional is having the money. What is going to do? He will distribute the money to all the persons who has raised the dispute. Now merely I am having the money, I cannot give you as per my wish. நான் எப்படின்னா அப்படி காசு கொடுக்கறேன்னா முடியாது. Again, you have to follow the procedure and pro forma prescribed insolvency bankruptcy code. Straight away you cannot give to whom whatever you want and you like. Some extorted transactions will be there. Fraudulent transactions will be there. All should be eliminated. ఇక్కడ మళ్ళీ వస్తుంది మీకు. ఫర్ ఎగ్జాంపుల్, కంపెనీ is going to know that somebody is going to initiate this process before NCLT. Company comes to know immediately what it is going to do. It will transfer all the properties. కంపెనీకి ఒక ఇన్ఫర్మేషన్ వచ్చింది మన మీద కేసు వేస్తారని చెప్పి, వెంటనే ఏం చేస్తాము? ప్రాపర్టీస్ అని ఏం చేస్తాము? ట్రాన్స్ఫర్ చేసేస్తాం. సో దట్ it is not included in your claim. So many things will come. So these should be eliminated. So whoever is having more than 1% stake, let it be equity stake, let it be preference stake, by whatever form it takes, you have to mention those persons in the information memorandum. Next one is all details of material litigations. Material litigations you have to take hold of all material litigations before the government, before the authorities. Right. Next one is number of workers and employees in the company. Number of workers in the employees and company. Number of employees and companies in the company. Workers in the company. Right. Now he has prepared information memorandum. Now there is one important concept is there. Even he can change the capital structure of the company. Capital structure. Right? How many types of capital are there? Company law. First one, which capital? Fixed capital law. Take which capital first one comes? Working capital law. Authorized capital. What is the first capital? Authorized capital. Next. Very good. Shareholders cap. Shareholders annave capital. Purunjida? No. Issued capital. Authorized capital. Issued capital. Subscribed capital. Called up capital. Paid up capital. And last capital. Reserve capital. Right. These are the capital structure. Capital structure. ఇవన్నీ ఏంటి? Equity. These are known as equity capital. Equity capital. Even debt capital is also there. Debt capital means you are taking debentures, secured loans, unsecured loans. ఇవన్నీ ఎక్కడ ఉంటుంది మీకు బ్యాలెన్స్ షీట్ లో? లయబిలిటీ సైడ్ ఉంటుంది. Where it is there? Liability side. That means here you cannot change the capital structure without getting approval of the members in a special resolution. Why? This is the structure which is mentioned in the memorandum of association. దీన్ని మీరు చేంజ్ చేయడానికి కుదరదు. చేంజ్ చేయాలంటే ఏం చేయాలి? What you have to do? You have to convene either the meeting of the shareholders, pass a special resolution. That is the only remedy which Companies Act speaks about. You cannot touch this capital. Why? It's a stakeholders money. Meet up one காசு கிடையாது கம்பெனில இதெல்லாம். யார் காசு இது? பப்ளிக்கோட காசு இது. You understand? Public money is involved in this company. You can start a company. You cannot close a company. You understand? Because I have started my company. Now I want to close my company. Law says no. Now Mukesh Ambani cannot close the company on his own. Why? Company does not belong to Mukesh Ambani, belongs to stakeholders. So if we want to change the capital structure, we have to take unanimous resolution of the members passed in a special resolution. Now, without passing the special resolution, without following the procedures prescribed in the Companies Act, now he is changing the capital structure. Capital structure change and procedure enti? Meeting convene cheyali, resolution pass cheyali, చేంజ్ చేయాలి. వీడన్నీ ఏం చేయట్లేదు, స్ట్రైట్ అవే చేస్తున్నాడు. వీని పవర్స్ ఎవరు ఇచ్చారో? బై వర్చ్యూ ఆఫ్ అడ్జుడికేటింగ్ అథారిటీస్ ఆర్డర్. By virtue of adjudicating authorities order, he is going to change the structure. Now he has prepared information memorandum. What information memorandum reflects? ఏం రిఫ్లెక్ట్ చేస్తా ఉంది అది? A very good position of the company. Why? To resolve the disputes. Now he has taken information memorandum and he is going to committee of creditors and he is presenting it to the committee of creditors. Let the committee of creditors know the position of the company, where we are going to stand. మనకి డబ్బులు వస్తుందా రాదా అని దేని చూసి తెలిసిపోతుంది. நீங்க பாஸா ஃபெயிலா எத்த பார்த்தா தெரியும், சர்டிபிகேட் பார்த்தா தெரியும். சர்டிபிகேட்ல பாஸ் ஃபெயில் அது வேற பக்கத்துல உள்ள வேற இருக்கும் திருப்பியும். ரைட் ரைட். Now He has prepared information memorandum so that let the committee of creditors know the things. Right. Next important thing is he will record any change in the ownership of the company. Any change in the ownership of the company. How ownership will be changed? Change in equities. Even he will give instructions to the financial institutions maintaining accounts of the corporate debtor to submit their relative accounts to the interim professional. వీళ్ళు ఏ ఏ బ్యాంక్ అకౌంట్స్ లో అకౌంట్స్ మెయింటైన్ చేస్తున్నారో వాళ్ళకి ఇన్స్ట్రక్షన్ ఇస్తాడు ఏమని, మీరు స్టేట్మెంట్స్ అన్ని కూడా నాకు ఇవ్వండి. Please send all the financial statements to me. Next, undertake any related party transactions also. Related party transaction is prohibited under Companies Act. I am not going into the intricacies of related party transaction. అది మీకు చెప్పినా అర్థం కాదు. Related party transaction. So he will undertake even related party transaction which is prohibited under the Companies Act. Right. Now, very, very important point is, before going into this, I will ask you, what are the constitutional documents of a company? Memorandum of Association, Articles of Association. Right. Can this be amended following the proper procedure? Right. That means you can amend the capital clause, but you cannot amend the object clause at any point of time. You understand? You can amend whatever articles you know. Articles of Association. Which table? Enna table? Wooden table. ఏం టేబుల్? ఏ తెలియదు. నో ఇష్యూస్. టేబుల్ ఎఫ్ మర్చిపోతే ఎట్లా? టేబుల్ ఎఫ్. టేబుల్ ఎఫ్ ఆఫ్ వాట్? கம்பெனிஸ் ஆக்ட் புக் எடுத்தா பின்னால ஷெட்யூல்ஸ் இருக்கும், டேபிள்ஸ் இருக்கும். அந்த டேபிள் எஃப் that consists of articles of association. நிறைய வச்சுக்கணும் மைண்ட்ல. டெரா பைட்ஸ் லாயர் அண்ணா ஜட்ஜி பண்ண போய் சார் நான் எல்லாம் மறந்து போயிட்டா சார். ரைட். யூ வில் கெட் தி ஆர்டர். யூ வில் கெட் தி ஆர்டர். விச் ஆர்டர்? டிஸ்மிசல் ஆர்டர். Right. It's your life. It's a constitutional right. Right. Now, you cannot amend the constitutional documents of a company without following the proper procedure. ఇప్పుడు ఏం చేస్తాడు? అందరి మీటింగ్ పిలుస్తాడా? పిలవడు. By virtue of the NCLT's order itself, he will amend all the constitutional documents of the company, namely memorandum of association and articles of amend பண்ணுவா. யார் amend பண்ணுவா? யார் amend பண்ணுவா? interim resolution professional. Right. No issues. ఏం జ్ఞానేశ్వర్ ఎవరు అమెండ్ చేస్తారా? ఇంటరిమ్ ఏం ప్రొఫెషనల్? రెజల్యూషన్ ప్రొఫెషనల్. Right. Next one. He will delegate his authority to any person also. Delegate any authority to any person also. Oh. Huh? అవునా రైట్ వస్తా ఉందా రైట్ నౌ he will amend the constitutional documents also. Even he may dispose of the shares of any shareholder of the corporate debtor. Shares కూడా అమ్మేయచ్చు వాడు. They are nominees to third parties. He may dispose of the shares. He may sell the shares of the shareholder of the corporate debtor or his nominees to third parties. He can sell the shares. If any shares are left with the corporate debtor, only thing is to get the money to resolve the disputes. Then make any change in the management of the corporate debtor, including its subsidiary companies. He can make any change in the management of the corporate debtor, including its subsidiary companies. Right. Now, even he can alter the terms of material contracts also. Whatever be the contract that has been entered into with the corporate debtor and with third parties, he can alter the terms and conditions of those contracts also. Now, that means he is a stranger to the contract, but by virtue of the order passed by the NCLT, he can materially alter the contract for the benefit of the corporate debtor. Everything will benefit of the corporate debtor. Only if the resolution fails, then only go for liquidation. Right. Even make changes in the appointment or terms of statutory auditors, internal auditors of the corporate debtor. He can make changes in the internal auditor, external auditor, statutory auditors also he can. Normally again, if you want to change the auditors, big procedure is there. Without following the procedure laid down in the law, by virtue of the order, he can change. So now he has prepared information memorandum. He has submitted before whom? Committee of Creditors. Right. Now, the Committee of Creditors is seeing the information memorandum. Both will sit and a resolution plan will be prepared now for the consideration of the adjudicating authorities. ఇప్పుడు ఏం చేశారు అంటే ఇన్ఫర్మేషన్ మెమరాండం చూసిన తర్వాత దే విల్ ప్రిపేర్ వాట్ రిజల్యూషన్ ప్లాన్. నౌ ఈ ప్లాన్ లో ఏమేమి ఉంటుంది, హౌ ఇట్ ఈస్ గోయింగ్ టు బి సీ ఇన్ ది నెక్స్ట్ క్లాస్. గాట్ సంథింగ్ టుడే? రైట్.
Brigadier General Girls, open floor room number 2. 3 years. 3 years General Girls, open floor room number 2. 5 years General girls. Fourth floor, room number 5. 5 year BBA BCom girls. Fourth floor, room number 7. Kindly 3 years general boys. Fourth floor, room number 2. 3 years. 5 years general boys. Fourth floor, room number 5. And BBA BCom. Fourth floor, room number 7. Please go silently, ma. Don't disturb others. Boys, leave the hall immediately. Please, don't disturb others. Those who are sitting at the back, come forward. முன்னாடி வாங்க. Hey, phone use பண்ணாதீங்க. Your phone will be confiscated. Settle down fast. Okay, good evening. What was the last class? International investment, right? So take down the landmark case. Take down the landmark case. Tokyo Toklas case 2004. Tokyo TOKIO. Tokyo Toklas case TOKELES. First, write down the fact of the case. Here, 2004, 2004. ARB bar 2 bar 80. Case number. ARB means arbitration. Okay. Tokyo Toklas case. Tokyo Toklas case. ARB means arbitration. ARB bar 2 bar 80. Case number. Okay. So listen to me first. This Tokyo Toklas is a bilateral investment agreement case. Okay, it's a bilateral investment. What is meant by bilateral? Only two countries will take place. That is
In this case, Lithuania and Ukraine, both country, Ukraine and Lithuania having a business. Like it is an advertising and publishing business. Okay, advertising, publishing and printing business. Both are having a contract. Okay. Tokyo Toklas, a business enterprise. Take down. Tokyo's Toklas, a business enterprise established under the laws of Lithuania, Lithuania, Lithuania. Tokyo Toklas, a business enterprise established under the laws of Lithuania, owned a publishing company in Ukraine. Owned a publishing company in Ukraine. They filed for arbitration. They filed for arbitration. They filed for arbitration as they were subjected to improper tax investigation by Ukrainian authorities. That hindered HINDERED, that hindered its business activities. Hindered means making inconvenience. The word hindered means making inconvenience to Lithuania country person who invested. Okay. That hindered its business activities. This reason was enough. This reason was enough for them to claim that Ukraine had breached the contract. That Ukraine had breached the contract in bilateral investment treaties. Now the matter referred to arbitration. Okay. Now the Ukrainian government claimed that because Tokyo's and Toklas was 99%. Tokyo's and Toklas was 99% owned and controlled by Ukrainians. It did not fall under the
definition of an investor. It did not fall under the definition of investor. Now you got what I said, right? The fact of the case is there is a bilateral investment agreement between the country Lithuania and Ukraine. Okay. Lithuania is investing their investment in Ukraine. Okay. And after certain period, the Ukraine is imposing tax, which is out of the rules and regulations. Okay. So that Lithuania is suffering. So hence the matter referred to arbitration under ICSID. Take down ICSID. The abbreviation for ICSID means International Center for Settlement of Investment Disputes. International Center for Settlement of Investment Disputes. At last, they are giving a award or reward. Which word is abrupt? Award or reward in arbitration? Award, yeah. At last, after the arbitration, the award is given in favor of Lithuania. You know why? Because Lithuania invested their investment in Ukraine. Okay, so the majority of the share invested by Lithuania. Hence, the case favored to Lithuania. This was the fact of the case. Okay, now you got no. It's a very, very famous case. Tokyo Topless case, the year 2004. Okay, next. Another case. Philippines case. Country Philippines. Philippines case 2004. Philippines case 2004. The fact, now write the fact of the case. Philippines entered into a contract. Philippines entered into a contract to provide import cargo inspection. To provide import cargo inspection. Actually, this contract between two countries, that is Switzerland and Philippines. Switzerland entered into Philippines to give cargo inspection service. Okay, take down. Switzerland entered into a contract, strike it Philippines
Switzerland entered into a contract to provide import cargo inspection. To provide import cargo inspection services for the Philippines government. Subsequently, the Philippines government did not make payment. The Philippines government did not make payment to the agreement and Switzerland requested arbitration on the grounds that such failure of payment constituted breach of contract. However, ICSID, what ICSID stands for? Very good. However, the ICSID declared that it would not accept the case and therefore it would not exercise its jurisdiction. It would not exercise its jurisdiction over the subject dispute. It would not exercise its jurisdiction over the subject dispute. Switzerland entered into a contract with the Philippines. Switzerland entered into contract with Philippines government agreeing to submit disputes only to domestic courts. Agreeing to submit disputes only to domestic courts. Which means here the domestic court means that matter should be dealt only in Philippines government. Is that valid? Is it valid or not? According to international investment agreements, is it valid or not? Justified. This should be done by you. And next class, you have to answer it. Then only I will proceed to other level. Okay. So within this, we will wind up today's session. Okay. So advance Happy New Year to you all. Okay. God bless. And are you all able to understand my lecture, man, in international trade law? Girls and boys. Pakka? Okay, okay. If you are not able to understand my lecture, please do ask me. I'm ready to answer you at any time. Okay? You should not go with ambiguity. கால் பண்ணுங்க சார் கால் பண்ணுங்க அஜித் சார் Please maintain the silence. Please. See, I can respect your, I can understand your feelings. Same time, you should understand the feelings of your masters. உட்கார்ந்து கிளாஸ் கேட்கிற உங்களுக்கு அவங்க வழி தான் வழி ஜாலியா ஏசி உட்காந்துருக்கேன் தூக்காம கிளாஸ் giving your information. ஆந்திர பிரதேஷ்ல எந்த லா காலேஜ்லயுமே இது மாதிரி கிளாஸ் எடுக்க மாட்டாங்க. So you are blessed in this class. So make use of this opportunity. Okay. There are so many students who are waiting. Few students got this opportunity. Okay. You will realize later the importance of these classes. Okay. So please pay attention to the teachers. When they are taking classes, it's all for your own benefits. Make use of the class. Please realize getting degree is easy, man. Anybody can get degree. The more version of what we learn, we question mark. This will be reflected when you go to court. Judging paper, paper, legal terms. When you are able to accept on the legal terms, definitely you will feel ashamed. But now the trend has been changed. Our college students are shining all over Tamil Nadu, Kerala, Andhra Pradesh. Seriously, I heard. So please don't come for the sake of attendance. Okay. I told you many times. ஒரு டீச்சர் பாடம் எடுக்கும் போது தனியா உங்களுக்கு ஏதாவது ஆக்டிவிட்டி இருந்தா போகலாம். In next class, you can ask. Okay. Okay. 3 years. Girls, when
Sir, you are splitting right? Splitted. Not splitted. Yes, not splitted. So not splitted. 5 years girls, honest girls. Please give your attendance to DVD, sir. 5 years honest girls. Please give your attendance to DVD, sir. And 3 years girls, give your attendance to Rishi, sir. Girls, please, please. Under the rule, please, please. Five years. Give your attendance to Girish Adit. Rohit. 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 Second row, 5 years students are Second row. Why? Third row. Third row. எல்லாம் listen. Side. Please go back. Please go back. Please go back. Five. Please go back. All right. Please students. Go back. Don't want. Five years. Nobody is. You keep the income or five years. 5 years, 5 years, 4 Second, 3 years, second row. 3 years, second row. Go 5 years, third row. 5 years, third row. Second row. No voice. And 5 years, fifth row. 5 years, fifth row. No voice, no voice. No voice. No voice. Don't allow. 5 years, sixth row. 5 years, sixth row. 5 years. Yeah, sir. Stop. Five years, sir. We want somebody now decide. Go ahead to top of our window, yeah. Last week of close for you. Close. There's no meaning. It's moving. One day, everyone Of your all activities. On behalf of our principal direction, take your WhatsApp message. Just now provided a message from director. Take you part. Some people are follow. Take the message. Yeah, it's the आपको पता है